Is the affidavit part of the recusal application?
Okay, firstly, Your Honor, I must say this for the record, I think your motives are dishonest.
Of course. The question I asked is whether the affidavit that came in on Friday is part of your recusal application.
And I'm clarifying that question. You're trying to distort the record. I'm trying to prevent you from doing that. What I'm saying is that the affidavit simply exhibits the documents that were lodged to commence the proceeding against you and the prothonotary. Those are 99% of the materials exhibited to that affidavit. The only other documents that are exhibited to the affidavit are the communications that we've had or we had until that time with the Registry in relation to the lodgement of that application and with Your Honor's chambers. So that affidavit simply puts into record the documents that are sought to be lodged in relation to the other proceeding that we were commencing against you. You do not need.
This is the IBAC one?
This is the IBAC one. You do not need to go through each of those documents, but that is there simply to provide a record of the allegations that were being raised against you.
All right, so if you are making your recusal application, will you refer to any of the documents that are in that exhibit?
Only to the extent that that proceeding and those documents in support of that proceeding were lodged. The law in this respect is very clear, and Your Honor has previously accepted it. When there are allegations raised about improper conduct by a judge, the judge is disqualified and another judge must address those issues. The Court of Appeal has made it very clear. Your Honor had previously said that the allegations that we were making were not of that sort. Now, because of what Your Honor did on Wednesday, the allegations are also of that sort. In those circumstances, we say that Your Honor is disqualified from. You didn't allow us to file the documents. But in any event, I'm simply relying, no, Your Honor. I'm simply relying on the documents that have previously been lodged. You've considered them before. We're saying that first of all, we want you to clarify whether you had, what sort of communication you had with the prothonotary, whether you've had any private communication with the LSBC. We say that you have improperly incited the LSBC to give perjurious evidence. You said on Wednesday that you were unconcerned with whether or not Mr. Anstey had committed perjury. He's or had lied on affidavit, and that will not be an issue in the proceeding. In our submission, that was an incitement. We have, and you said that after we've given you documentary evidence of his lies. Your Honor, the law, first of all, you have to decide whether my submission in respect of the law in this matter are correct. My submissions are that the law does not entitle Your Honor to continue to sit in the matter. There is no matter of discretion here, so whatever order Your Honor is referring to is inoperable in circumstances where these astounding developments have taken place. You also improperly concluded the hearing of the other matter in the perpetration of a fraud on me.
All right.
I was not made aware that you were considering the matters you were considering. I was not given an opportunity to address the court in respect of that. And all those developments have taken place after the making of the orders. We sought to seek leave to file the material. You also prevented that. It's completely in.
My concern is that if you are given an hour or so to present a recusal application, and it's the first time that, without any advance submission in relation to it, it puts everybody in a very difficult position in knowing how to deal with that at the time. Which is why I have required something in writing to be circulated in advance so that I, and also the board, if they want to get involved in the matter, know what your argument is going to be with some precision.
You know what the argument is.
I know that you are complaining about my conduct, but
no, that you conspired with the prothonotary to prevent the lodgement of the documents.
Okay.
Look, Your Honor, this is a matter of public record. It's been written to Mr. Ansell wrote to the Registry and alleged as much. That document is a public record. We're publishing it online. And essentially, I can rely on it as a.
What are you saying I've stopped the prothonotary accepting?
You admitted on Wednesday that you had communicated with the prothonotary in relation to the acceptance of the proceeding. You came back in court and said that you've spoken with the prothonotary yourself about.
I haven't. I didn't say that.
You did say that. It's on the transcript as well. I distinctly remember. I noted it down. I made.
All right. So this is now an argument you wish to make, where you're referring to particular things that were said in court the other day.
No, I'm saying.
You are.
What happened behind the.
Yes. Okay.
I'm talking about the communication that took place that I suspect you've not properly apprised us of. And I'm also requesting the board to confirm whether or not it has happened in private communication with the LSBC in relation to me or People Shop, particularly in 2021. We had previously asked Your Honor about this. Your Honor had not responded in circumstances where Your Honor encouraged the contravention of the uniform law brought by Mr. McAuliffe.
Mr. Ansell and Ms. Zhu are not here, and I consider them not to be in court at the moment. You're here.
Okay, they've written to the registry. Mr. Ansell has himself written to the registry and alleged that you have. So, Your Honor.
I'm sure that they would agree with what you are saying. I'm not saying they wouldn't agree with what you're saying, but in terms of...
Well then, you have an obligation under the law.
In terms of formality, I don't consider you to be appearing for them.
Okay, well, the matter is very simple. Either we're in contempt of court or what has happened is extremely worrying and the public interest in maintaining the public confidence and the administration of justice requires that these allegations against a judge of the Supreme Court not simply loom and fester. My submission is that in circumstances where I'm alleging that you have encouraged Mr. McAuliffe to continue to break the uniform law for personal gain to oppress us or to aid the Legal Services Board in oppressing us further, and you had evidence of that before you. Mr. McAuliffe also, he has never filed any evidence in response or addressed the substance of those allegations, the allegations being that he has submitted to Justice Guinan that Mr. Rapke waived my legal privilege when he allowed he said that in writing. He said that in writing. The written submissions are in evidence before Your Honor. They're exhibited to a previously filed affidavit in this proceeding. He said in writing that the Legal Services Board may have been entitled to waive my legal privilege when they allowed Senetharaja and his.
Mr. Kuksal, I'm not interested in hearing all your criticisms of Mr. McAuliffe at the moment.
No, I'm saying that you incited him to continue.
Okay.
You encouraged him to continue.
Mr. Kuksal, sit down, please.
And in those circumstances, we say that it's improper.
So it's clear that Mr. Kuksal wants to bring a recusal application. I wanted to get some clarity from you on whether I understood the application that was being listed was going to be one that was not dependent on evidentiary findings and the like. That is, I had previously listed certain paragraphs of the plaintiff's summons as hearing at the same time, and they were not listed because, as I remember,
you stopped us from subpoenaing them.
As I remember it, I'd granted leave to file some subpoenas, and the situation being put by Mr. Kuksal was and the other plaintiffs that they're in the evidence gathering process still, and so it wouldn't be right to have a determination of those paragraphs, that there is no evidence to support them, for example, because the evidence was still being gathered. No, that's all right. All right, Mr. Kuksal, can I say this? I do consider that I have made it clear to you that recusal applications are to be anticipated by a written submission, so that the parties and me, more importantly me, am not in a position of hearing the substance of the recusal for the first time in court because of the risk that causes to delays in the proper development of the matter. Nonetheless, in the circumstances I'm going to, it's 5 to 11, or just before 11 now. I'll give you until 12 o'clock to present argument on the recusal application, and then we'll reflect on how we go about it after that.
Thank you, Your Honor. I'll start.
I just want to say, Mr. Kuksal, I won't say any more. Sorry, go on.
So, Your Honor, I request that the court call Ms. Zhu and Mr. Ansell to confirm that they join in the application because it would be contrary to their interests that Your Honor improperly exclude them from this matter like Your Honor did with me on Wednesday. There is no reason they are not attending court out of choice. They are obliged to not attend court, and I am a plaintiff along with them, and in circumstances where that is the case we have a joint interest. We are joint plaintiffs, and I have always made submissions on behalf of everybody. Your Honor has, in fact, prevented people from making additional submissions often. There is no reason why I should not be able to present the joint submissions that we have together agreed upon in circumstances that Your Honor may have any issues with that. I request that the court contact them via phone. They have also indicated that I should convey this to the court, and Your Honor has previously indicated just today that you have no doubt about the fact that they join me in those applications, that they concur with me. And I have brought 3 emails digitally, or copies of them, that we have exchanged with the registry since the lodgment of the affidavit of Ms. Zhu. Those emails further indicate what Mr. Ansell's and Ms. Zhu's positions are in respect of what the court is doing, and I'd request that the court accept those documents. They are a matter of the public record now.
Sorry, what documents do you want me to accept?
So there's an email that was sent, I'm just bringing up the affidavit the affidavit of Ms. Zhu that was lodged on Friday.
Yes.
That affidavit has an exhibit folder. The folder is Lux.
I don't have the folder. I don't have the exhibits, Mr. Kuksal.
They were downloaded this morning, Your Honor.
Well, I don't have them. They are so big,
Not all of them are. Just one of them is. But the one that I'm referring to is LX3, which is it's less than 20 pages, the LX3 exhibit. Or it's a folder which has less than 20 pages of email exchanges. In addition to the 5 files that are at the LX3 folder, there are 3 other documents. The first one is only 1 page. The second one is only 3 pages. And the third one is around 5 pages. So 1, 3 and 5. And not all the pages are full of text. We're basically talking about around 9 pages of.
I'm telling you I can't access them. I can't look at them.
So I can provide the documents via email. I'll tell you what they are.
Well, how many pages?
I just said.
Of documents are you going to want me to look at?
Less than 10 pages. Less than 10 pages.
10 pages. All right. Well, why don't you email my associates now the 10 pages that you want me to look at which are extracted from that exhibit?
No. They are in addition to Lux 3. They are a continuation. So LX3 exhibits our correspondence with the court and the registry. These are the exchanges that have taken place after the lodgment of that affidavit.
So I ask again, what pages and how many pages do you want me to look at in the course of the next hour when you are bringing your recusal application?
Okay, I'd say less than 30 pages maybe. Less than 30 pages.
Well, how am I going to find those pages?
I can email them right now.
All right. Well, do you want me to stand it down for 5 minutes?
Yes, thank you.
So I'll stand it down for 5 minutes and you can circulate the 30 pages or thereabouts that you want to look at.
Yep, thank you.
For your recusal application. All right. I have 12 documents.
12, yes, 12 documents. So Your Honor, those are the documents that I'm seeking to rely on in addition to the affidavit of Ms. Zhu.
Can I tell you I'm not going to look at anything in the affidavit? Ms. Zhu's affidavit simply produces documents.
We rely on the documents that were lodged to commence the proceeding. We want that to be part of the proceeding against Your Honor and IBAC.
IBAC. All right. Yes, so you rely on the fact that you sent to the prothonotary for filing a proceeding which included allegations against me and Mr. McAuliffe.
And the prothonotary itself. And then Your Honor asked or raised some issues about that matter in court with me for the same reasons the prothonotary rejected the lodgment in circumstances that Your Honor has also confirmed that Your Honor personally spoke with the prothonotary. And
I don't accept that, Mr. Kuksal, just for the record.
Well, those are.
Yes.
Those are the allegations.
Yes.
And a different judge should decide the issue of fact in relation to the matter. It's improper for Your Honor to do that himself. And I've previously cited the authority, I will cite again, and Your Honor has accepted it in relation to factual matters. We also say that the LSBC has, in our view, communicated with the prothonotary.
If you want me to look at these documents in this next, till 12, you better take them to me and tell me what you want me to make of them.
Yes, so Your Honor, if I could just get a minute too, I can also provide Your Honor with the submissions or the list of authorities that Your Honor had previously asked. I've just put them in the right.
No, Mr. Kuksal, you're making your submission now.
I will be making my submission now, yes. But if you wanted, I'm going to cite the paragraph numbers from the various authorities, but if Your Honor needed assistance for convenience, I can also provide you with a copy of those. But I will quickly list all the paragraphs from all the authorities that I would rely on in the interest of being efficient so Your Honor can address that in Your Honor's reasons. Okay, so Your Honor, I note that it's 11.25 and I'm going to commence my application now. So the 12 documents that I have provided to the court are.
Mr. Kuksal, you've commenced your application.
At 11:25, yes.
No, you commenced it when you started trying to get the documents together you wanted to rely on.
Well, Your Honor, that's absurd. That's just absurd, but anyway.
Okay, well, take me to one you want me to look at.
So firstly, I refer to the email that was sent to the registry this morning. This is an email from me sent at 9:13 a.m. It's called 26.08.24 SK to SCV, new case request 434,486 feet. This is in relation to the registry's response to us. That email, by the way, is also in the bundle of documents. That email is called 23.08.24 SCV to SK, new case request 434,486 feet. In essence, what has happened is that the prothonotary refused to accept the lodgment of the documents without looking at the evidentiary documents. So first, when we lodged the proceeding with the affidavit, we were told that they needed the exhibits before they can accept the affidavit for lodgment. When we tried to give them the exhibits, they said that they can't accept the exhibits until the affidavit is lodged. We then wrote to the Registry and said that this was obviously scandalous and in perpetration of perversion of the course of justice to prevent us from accessing the court. Immediately after that, the prothonotary wrote to us and rejected the finding on the basis that it would oppress the defendants because of the number of defendants. That was an issue that Your Honour had raised about the number of defendants in the proceeding. The second matter that was raised was that the proceeding sought to improperly prevent the advancement of this proceeding and the related LSB proceeding, which again is a view that Your Honour has previously expressed.
Which document am I meant to be looking at?
I'm clarifying the context of the documents. Then we wrote to the prothonotary and told them that we wanted the matter to be escalated to a judge. So this was the response that we received from the Registry. This is the 23.08.24 SCV2 SK new case request. And in that document they say that we can commence an administrative proceeding to essentially have the matter considered by someone else or a judge, but in an administrative capacity. Now, I take Your Honour to the email that I sent to the Registry in response to that email this morning. That email the file is labelled 26.08.24 SK2 SCV. I said I attached there to that email a copy of the email that Mr. Ansell had sent to the Registry on the 23rd of August. That document had been exhibited to Ms. Zhu's affidavit in the folder Lux 3. Now, this is on P4 of that document, the 26th of August 24 SK2 SCV. Can Your Honour see that document?
I'm just having trouble with some of them. I've got a 6-page document. Can you?
Page 4 of that document is the letter that Mr. Ansell had written to the Registry. And there, he notes that we've now had an opportunity to review Mr. Ratcliffe's reasons, which are a matter of public record, and find them misleading. In the circumstances, so first of all, we should point out that Mr. Ratcliffe said that we had complained about the IBAC not ruling on time in accordance to our satisfaction. That was an absurd thing to say, because what we were alleging is that they have breached their statutory obligation to give a preliminary decision in respect of whether or not the matter raised public interest issues. They have a statutory obligation to do that within 4 weeks. They didn't comply with that. It was a very open and shut matter. Also, Mr. Ratcliffe sought to act as a judge in his own matter because he was a defendant in the proceeding, which is impermissible. I also note that he implied that we were seeking a review or challenging the decisions of 27 defendants. That wasn't the case. We were simply seeking a review of the decisions of 2 bodies. The Supreme Court General Civil Procedure rules oblige us to include the other parties because they were the parties against whom we were complaining. This matter has been decided by Justice Ginane against the LSB in a matter, and I will just cite the decision of His Honour, where His Honour pointed out that a party is obliged to include as defendants parties that were involved or would have been affected by the original decision. Just bringing up the citation for that is Kuksal v. State of Victoria, 2023, VSC 438, and I refer to paragraphs 14 to 22 of that decision. And I will read this just for emphasis. In my opinion, the board remains a proper and necessary party. So what had happened in that proceeding was that I had subpoenaed the board in the magistrate's court, and the magistrate had dismissed the subpoena. I alleged that it was because the board had misled the magistrate, and the board then brought an application that they shouldn't have been included as a defendant in the matter because I was only seeking to challenge the decision of the court. I made submissions which His Honour has referred to in the paragraphs that I cited. His Honour accepted my submissions. And this is what His Honour said: in my opinion, the board remains a proper and necessary party for the purposes of Rule 9.06. In judicial review proceedings, it is common for a plaintiff to join as defendants not only the decision maker or the court or tribunal. The IBAC was the tribunal in that instance, and the Victorian Inspectorate was also a tribunal who has made the challenged order, but also the party who sought the decision or order. In that case, the LSB had sought the decision or order. The rule strictly is that any party whose interests are affected, and I cite Woodman v. IBAC about that proposition as well. Any party that is affected by an order must be given an opportunity to be heard. The citation for that is 2022 VSC 684. So going back to what Justice Ginane said, that is because it has an interest in maintaining the order that is challenged. That interest continues whether or not the party chooses to take an active part in the proceeding. The board certainly took an active part in the magistrate's court application concerning Mr. Kuksal's summonses. The board apparently sought the orders that were made striking out the summonses. The summonses in issue are directed to an employee of the board and to a person appointed to carry out functions in connection with a legal practice. That was Mr. Rapke. It was not suggested that the 2 persons should have been joined as defendants themselves to this proceeding. Okay, this is irrelevant, this part. In addition, this court may seek submissions from the board and expect it to act as a contradictor about issues concerning the summonses. That was also a submission that I had made, citing authority in that respect that have to be decided. In that way, the board, which is a statutory authority, may assist the court. So it was completely proper for us to join the parties against whom the complaints were made. The complaints were only made against IBAC and, The proceeding was only being commenced to challenge the decisions of the IBAC and the Victorian Inspectorate. Those parties were not obliged to participate. They could have simply handed in submitting notices if they didn't want to participate. All that we did was give them an opportunity to be aware of the proceeding and to assist the court further. In any event, the matter was decided by a defendant or a proposed defendant in that proceeding, and the decision was thus scandalous. We also add that it was a judicial decision that was made, which is not the sort of decision that 28.04 contemplates. So in Mr. Ansell's letter to which I was referring earlier, he says in paragraph 3 that Mr. Ratcliffe prevented us from filing exhibits to the affidavit of Ms. Zhu in support of the originating motion. Having obstructed us, this is paragraph 4, having obstructed us from filing the evidentiary documents, Mr. Ratcliffe then relied on their absence to assert the inadequacy of our lodgment in relation to the evidence of the matters alleged through the originating motion. Moreover, not only are decisions that Mr. Ratcliffe has purportedly made fundamentally judicial in nature, the decisions that Mr. Ratcliffe has made fundamentally judicial in nature, they also presume that the law prevents the lodgment of further evidence following the commencement of the proceeding. Then it asserts that that's not the first time Mr. Ratcliffe has adopted these tactics, which is why he had been the subject of the complaint to IBAC in the first place. We are concerned that a judge who may review this matter on the papers will not be provided the documents that they ought to receive, and we will not be given an opportunity to address the matter in relation to Mr. Ratcliffe's improper conduct acting as a judge in his own cause and the incontrovertible documentary evidence of his prior collusion with the LSBC. I have phone recordings of my discussion with the Deputy Prothonotary, which transcripts of which were exhibited to Ms. Zhu's affidavit, where the Deputy Prothonotary makes admissions about the Prothonotary's potentially improper correspondence with the LSB, on account of which the Prothonotary had been misled into believing that Mr. Ansell did not have a practicing certificate when he, in fact, did. And on account of that, he had rejected the lodgment of the originating motion in this proceeding, or delayed it, rather, which permitted the LSBC to start the other proceeding before our proceeding. That's one of the main allegations being raised against the Prothonotary. Then Mr. Ansell says that we also note that Justice Gorton, another defendant in the proposed proceeding, admittedly communicated with Mr. Ratcliffe in relation to our application shortly after it was lodged on Wednesday. Given His Honour's comments in court in relation to our application on Wednesday and on previous occasions when it had been merely foreshadowed, and Mr. Ratcliffe's repetition of some of those comments in his reasons, we are concerned that Justice Gorton may have improperly influenced or motivated Mr. Ratcliffe in taking what we consider to be a detrimental action against us. Moreover, given the Victorian Legal Services Board and Commissioner's Office and their counsel, both their conduct on Wednesday and Mr. Ratcliffe's past improper coordination with them to obstruct the commencement of our proceeding against the LSBC, we are concerned that the LSBC may have also improperly coordinated with Mr. Ratcliffe prior to his decision to reject our application yesterday. The matters certainly bring the administration of justice into disrepute, especially at a time when public confidence in the judiciary is at a historic low in Victoria. It cites the report that was published by 3AW on the 29th of July, which said that there's a 30% public confidence in judiciary in Victoria currently, which are historically low levels of confidence. And that's before all these matters have been discussed in the public forum. We demand that you provide us with records of your communication with Justice Gorton. I think there's a typo here. It obviously should have been, or his associate, but it says, of his associate.
Yes.
As well as the LSBC and its agents by no later than 5 p.m. today. Over the last few months, we have repeatedly raised concerns about the Prothonotary's unlawful interference in our ability to access the court. We have requested that our complaints be escalated to the judge responsible for the administration of the court. Unfortunately, those concerns have remained unanswered. In light of that, we intend to publish an open letter through change.org addressed to the Chief Justice of the Court, Her Honour Anne Ferguson, Justice Keogh as the head of the Common Law Division, the Attorney General of Victoria and the Human Rights Commission, to make him and the public aware of the extreme oppression to which we have been subjected over the last 2 years on account of the cumulative corrupt conduct of the LSBC, Justice Gorton and Mr. Ratcliffe, along with the IBAC's failure to perform its statutory functions. This was one of the points. The other point is that the intent to raise these issues with the IBAC is an extension of our complaint against Mr. Ratcliffe. And in the event that the prothonotary does not confirm by 5 p.m. that the court is willing to put our challenge to the prothonotary's decision before a judge in a manner that allows us to provide them with the aforementioned documents, then we will start a separate proceeding to judicially review the decision. In response to that, the Registry wrote to us on the 23rd before the expiration of the deadline and clarified what the nature of the proceeding would be. I then responded to the Registry this morning and said that we are uninterested in an administrative proceeding and the allegations of the sort that we have made must be settled in open court, so we will commence a judicial proceeding to review the prothonotary's rejection and to address our allegation that Your Honour or the prothonotary had been improperly influenced by Your Honour and Mr. McAuliffe and the LSBC. We intend to subpoena correspondence in that matter, and we also intend to include the Attorney General and the Human Rights Commission in that matter from the start. We, because of the public interest in the matter and because of the Attorney General's failure to ensure proper administration of justice in the state. So those are matters that have been raised with the Registry. I note that any communication with the Registry is a matter of public record. And in addition to that, I also refer the court to a document that's titled 21.08.24 feet. This is SK and McAuliffe allegations against McAuliffe.
Yes.
This sets out, I haven't included the attachments to the email. There were, just because of Your Honour's allergy to voluminous documents. I note that the correspondence indicates that I had pointed out specific evidence to Mr. McAuliffe. I'm sure he will not lie as brazenly as refusing the documents that were attached or what they were. One of the documents was an affidavit of Mr. Ansell affirmed on the 24th of May 24, which has been filed in this proceeding as an exhibit to other affidavits. In that affidavit, Mr. Ansell exhibits a transcript of a proceeding in the Magistrates' Court where Mr. McAuliffe was representing the LSB and he sought to improperly prevent the disclosure of documents that were sought through subpoena, and he made some very scandalous submissions. He also influenced another party that had been subpoenaed to essentially, so that party was not seeking a very large cost amount against me after the dismissal of the subpoena. Mr. McAuliffe then influenced him, the barrister, to seek a higher amount in the costs application, following which that party did. That matter was documented in real time and raised in court, and then the transcript is exhibited. Also exhibited to the email that I'd sent to Mr. McAuliffe was an excerpt from the transcript of the hearing before Justice Ginane where Mr. McAuliffe had raised the submission that Mr. Rapke could lawfully waive my legal privilege and allow the reporter from Channel 9, Mr. Sam Kukiara, against whom I had a proceeding at the time, to record on video the contents of the case files that the firm was maintaining in my matters, including the matter against him and Mr. McAuliffe's misleading submission to the court that an Anna referred to in the police correspondence with Ms. Delara Anaz was not Anna Alavizopoulos of the Legal Services Board. The police later confirmed that it was, in fact, Ms. Anna Alavizopoulos. So those documents were exhibited to the email that was sent to Mr. McAuliffe. That email and another email that is provided to Your Honour this morning, 20, that is also called 21.08.24 SK and McAuliffe, commencement of proceedings against McAuliffe. That sets out the matters that Mr. McAuliffe had been notified of. We note that
This is the email that says at the top, matters raised against you with the IBAC. The 21st of August.
Automatic reply, yes. Automatic reply, matters raised against you. And then the other one just says, matters raised against you with the IBAC. So there are two emails. So this was because we suspected that he will not inform the review committee of the evidence against him, and we simply wanted to put him on notice that we will independently later put these documents to the Victoria Bar Review Committee and also seek to subpoena his communication with them in the public interest. We note that Your Honour clearly encouraged Mr. McAuliffe to continue with the matter and refused to hear us about the contravention of uniform law if Mr. McAuliffe continued. So we say that Your Honour encouraged a breach of the uniform law against self-represented parties that are being oppressed through the improper conduct of these proceedings. Now, I also note that in the correspondence that is provided to Your Honour, another exhibit is, or another document exhibited is one that is titled 26.08.24 indistinct to IBAC and VI. Urgent complaint against the IBAC and the VI. That was to put the IBAC and the VI on notice of the matters raised through the originating motion. That was lodged in the proceeding. And to say that they should consider those matters as additional administrative complaints against all the defendants as well as additional administrative complaints against themselves. In those circumstances the VI is obliged to raise the matter with Integrity and Oversight Committee. I think I've written Commission by mistake. And the IBAC is required to raise those matters with the VI. So that email, and then, so that was to raise complaints about Your Honour's conduct on Wednesday and the prothonotary's conduct on Wednesday and the LSBC's conduct on Wednesday, and there were documents exhibited to this email. I've just sent it again. It's a single attachment, one-page document in the event that it wasn't delivered initially. So it's an email from this morning, 9:28 a.m. It was sent by me to the Commissioner of IBAC and their General Reception, to the General Reception of Victorian Inspectorate, and to Chloe Armstrong, who's the principal lawyer at IBAC.
Yes.
It basically exhibited all the documents that were sought to be filed as evidence in the proceeding and the additional email exchanges from this morning and previously, and essentially asked the IBAC and VI to include the matters as either a new complaint against the parties against whom allegations are made or an extension of the complaints that have been previously made. It also put them on notice that, of their obligations to escalate the complaint against those bodies themselves to the appropriate oversight body. In the case of the IBAC body is the VI, and in case of the VI, the body is the Integrity and Oversight Committee.
So far, Mr. Kuksal, you've taken me to the complaints you've made about the profanatory and the...
And Your Honour.
Yes, and the complaints you've made about Mr. McAuliffe.
So that's the evidence, and I've also advised the court of the specific allegations.
Okay, so I work on the basis that you have made very serious allegations against various people.
Against Your Honour, the profanatory, and Mr. McAuliffe.
Yes, okay, now you've got to make a submission about why I have to recuse myself.
Yes, so firstly, in the correspondence that I had sent to the court on the 26th of June, which Mr. Ansell had forwarded, there was...
I'm only looking at the documents that you've told me to look at.
Yes, you previously considered this. It's part of your reasons. So the authority that I had cited, which Your Honour had addressed, is CUR 24 versus DPP. The citation is 2012-83 NSWLR 385. And there it was said that the correct approach to the assessment of applications of this sort is that where there is plausible evidence of improper conduct of the judicial officer, the relevant principles do not require a report exercising a valid or supervisory jurisdiction to first resolve by making findings of fact any dispute about what was said or done before applying the fair-minded bystander test. In this we add that we have repeatedly alleged, and Your Honour has, indistinct, accepted that Your Honour has previously relied on evidence that was provided to the court ex parte. It was not before the court in the proceeding. This is the indistinct proceeding review, and
you're now relying on material that you previously relied on numerous occasions.
It's a combination. That's how the law operates. It's a combination of. In particular, we're saying that Your Honour has never refuted that, despite us specifically raising it.
And remind me what the evidence that you're concerned about on that point was.
So Your Honour had been provided a copy of the order of the Magistrates' Court.
No, but what did I have regard to that you say I shouldn't have had regard to? And what did the order say?
That a permanent intervention order had been purportedly made against me. Your Honour specifically relied on that for reasons that Your Honour gave. That matter was not before the court.
So it's not that what I relied on was wrong, it was wrong for me to rely on it.
No, it was wrong as well. It was wrong as well. And that was also addressed.
All right, anyway, sorry, I keep interrupting.
And Your Honour relied.
I'm just telling Mr. I'm letting, time is going to run out. I understand.
Well, you're interrupting me.
No, listen to me, because I'm trying to get you to focus on this. I understand that you make serious allegations against everybody. The question is whether...
Not everybody. See, that is. No, 3 people in respect of this matter, Your Honour, Mr. McAuliffe, 4, let's say, the LSBC included, and the profanatory, and those allegations have not been denied by any of those people.
Okay, but I really want you to take me, then, to why you say the fact that you've made those allegations would cause the fair-minded.
Yes, and I was, before Your Honour interrupted. So CUR 24 versus DPP says that where there are factual allegations made, the court is not required to settle the truth of them.
Yes.
Because the test is that if one person can believe us, then Your Honour cannot settle this matter.
But what about the countervailing view that you should?
There is no countervailing view because if there is any possibility that Your Honour is not going to be an ideal adjudicator in this matter, then it should go to a judge whose conduct is not impugned in any manner. There is no countervailing interest over this. You cannot have an imperfect judge or a judge against whom those serious allegations have been made assess the matter. And those allegations cannot be made properly against a judge in the first instance. It's a criminal offence to do that.
All right.
The fact that this matter will be discussed in public. It will without doubt bring the administration of justice into disrepute if these allegations are left unanswered. In particular, I take your honour to the authority of Co v New South Wales Bar Association. In that matter, what was said is that if there are serious allegations raised against a lawyer, then the lawyer is obliged to refute them on affidavit because it brings the administration of justice into disrepute otherwise. Justice Dixon, who was the head of the Common Law Division in this court, has cited Co in Belitho v Banksia in respect of the administration of justice being plagued by scandal if those matters are not resolved. So in Co v New South Wales Bar Association, the citation is 2000 NSWCA 13, and I refer to paragraphs 11, 20 and 21. And I read from this paragraph 11. In Reby, 1981, 2 NSWLR 372 at 382, President Moffat said, "It is of the utmost importance that this court can order its procedures and give its decisions in the confidence that the barristers appearing before it will not mislead it." That's exactly the opposite of what Your Honour did on Wednesday and throughout the conduct of these proceedings.
Yes.
Your Honour said that it was irrelevant that these people have lied on affidavit and that brought the administration of justice into disrepute. Will conduct themselves in accordance with the law and discharge their duty even when not subject to scrutiny. There was evidence, this is paragraph 20, there was evidence that only a week or two before he saw that affidavit he had before him the documents which demonstrated the falsity of the statement. Exactly the point that I had raised with Your Honour when Your Honour said that it was irrelevant what the motivation was and whether the person had lied in swearing the affidavit. I'm referring to Mr. Anstey and Mr. Davidson. To my mind, the charge against him is proved by the mere fact that he swore to such an extraordinarily unlikely statement. One can only wonder what induced him to do it. On the face of it, the motive must have been to deceive his wife or the court or both, so on and so forth. Then the court says, the mystery is complicated by the admissions made by him through his counsel to the tribunal that the figure was wildly incorrect, that he was negligent in stating it, and that at the time he made it, he had a generally knowledgeable view of what the accurate figure was. In these circumstances, one would have expected Mr. Co to mount the witness box and explain the mysteries. He did not. He was offered the opportunity. In our case, Your Honour prevented us from raising those matters to the LSB. Whether or not Your Honour is taking a bribe is beside the fact. The fact of the matter is that Your Honour has a joint interest with the LSBC to prevent the truth of these matters from coming out, and I will self-immolate to bring attention to the matter if I have to.
Sorry, what do you mean by that?
I will light myself on fire to get attention to this matter if I have to.
To which aspect of the matter?
The fact that Your Honour has been suppressing the evidence in this matter and improperly assisting the Legal Services Board to get away with blatant and criminal breaches of the uniform law.
So what court case were you reading from just now? Was it Co
v New South Wales Bar Association.
Yes.
2000 NSWCA.
No, I've got it. I've just got that in front of me now. What paragraph?
11, 20, and 21 are the paragraphs that I read from. But I also refer to Belitho v Banksia Securities Limited, number 18.
Yes, all right. See, this is why you're meant to put something in writing beforehand, so these cases.
I was reading from the letter that has been provided to Your Honour that you ruled on before.
Well, this is why you're meant to put in a submission, so we're not running around trying to bring up cases in court and listen to them.
Your Honour, I don't think that is the remarkable thing in all of this. The disruption that you've caused to our proceedings, completely arbitrary and spontaneous redirection of matters that you have caused just to prevent us from getting the truth of the matter from coming out, that is the real cause of the disruption in this matter.
All right.
And it's an extraordinary thing for Mr. Ansell to allege that, too. Is not one to easily make those allegations. Now, I refer to Belitho v Banksia Securities Limited, number 18. Citation is 2021 VSC 666. In that authority in paragraph 1386, His Honour referred to Co v New South Wales Bar Association and New South Wales Bar Association v Meeks, MEAKES 2006, NSWCA 340.
Okay, I've got paragraph 1386 of that decision open.
Yes, so there, His Honour refers to in subparagraph C, Co v New South Wales Bar Associate. And 129, and I also refer to paragraph 1389 of that.
No, I'm at P 1386. Tell me the reference to the case. Where's the reference to the case?
It's subparagraph C.
Is it in a footnote?
Yes, and more importantly, I refer to paragraph 1389, where His Honour refers to those two authorities again. And His Honour says, when a prima facie case is established that a person who is subject to a duty of candour may have contravened an overarching obligation, we have provided evidence to the court on affidavit, plenty of affidavits, that they have breached an overarching obligation, and the person fails to give evidence, the court may more readily draw an unfavourable inference. In this case, the court basically says, why don't you make an application that is irrelevant so I can dismiss the matter on summary? If a legal practitioner invites the court to accept an explanation for their conduct, the explanation cannot be put by submission. This is what His Honour said in paragraph 1389. They have an obligation to meet the situation by explanation on oath and should enter the witness box at the hearing. Here, Your Honour said, what is the whole point of it? It was irrelevant to the lynching of the defendants that His Honour had predetermined. Now, I'm going to refer to another authority. I'll just read the passage first and then cite the authority. There are two types of law, just and unjust. One has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. I would agree with Saint Augustine that an unjust law is no law at all. Now, what is the difference between the two? How does one determine whether a law is just or unjust? A just law is a man-made code that squares with the moral law or the law of the gods. An unjust law is a code that is out of harmony with the moral law. To put it in the terms of St. Thomas Aquinas, an unjust law is a human law that is not rooted in eternal law and natural law. Any law that uplifts human personality is just. Any law that degrades human personality is unjust. An unjust law is a code that a numerical or power majority group compels a minority group to obey but does not make binding on itself. This is difference made legal. By the same token, a just law is a code that a majority compels a minority to follow and that it is willing to follow itself. This is sameness made legal. Sometimes a law is just on its face and unjust in its application. For instance, I have been arrested on a charge of parading without permit. Now, there is nothing wrong in having the ordinance which requires a permit for a parade. But such an ordinance becomes unjust when it is used to maintain segregation and to deny citizens the First Amendment privilege of peacefully assembling and protesting. I hope you are able to see the distinction I am trying to point out. In no sense do I advocate evading or defying the law, as would the rabid segregationist. That would lead to anarchy. One who breaks an unjust law must do so openly, lovingly, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and who is willing to accept the penalty of imprisonment in order to arouse the conscience of the community over its injustice is in reality expressing the highest respect for law. That was an excerpt from the letter from Birmingham jail that Martin Luther King Jr. had published. What was said in that letter was adopted in part and principle in A.V. Hayden. Citation is 1984, 156 CLR 532. The public interest in the enforcement of the criminal law is not diminished because it now depends not on any duty or obligation on the part of the citizen to give information concerning the commission of an offence but on his freedom to decide what action he will take. In Australia, it is no defence to the commission of a criminal act or omission that it was done in obedience to the orders of a superior or the government. Military and civilians have a duty to obey lawful orders and a duty to disobey unlawful orders. Any defence that conduct out of which this case arose was in obedience to orders which were not apparently unlawful may arise in other proceedings, but it is not pertinent. Then in Strickland v. DPP 2018, HCA 53, His Honour now Chief Justice Gageler said, as paragraph 153, ours is not a system of justice in which courts and law enforcement agencies exist in some sort of continuum. Between the two, there is a sharp, constitutionally mandated division. Courts, in exercising their own powers, should be careful to guard against creating a tendency for the public perception of that division to become blurred. As I have emphasized from the outset, the power of a superior court to stay its own proceedings as an abuse of process is a power to protect the integrity of its own processes, which Your Honour has never cared about. It is not a power I was referring to. I was making an allegation against Justice Gorton in that. It's not reading from the authority. It is not a power to discipline or to punish those who might bring those proceedings or those who might stand behind them. Its focus is on prevention of the court's procedures being used in a manner that is inconsistent with the due administration of justice. In a case where use of the court's procedures would be substantially unfair, the inconsistency lies in the administration of justice by the court being converted into an instrument of that substantial unfairness. I also refer to, and I'm not going to read but I'll say for the transcript, paragraphs 249, 256 to 249 and 256 of the same authority, Strickland v. DPP, 2018, HCA 53. I refer to Corporation of the City of Enfield v. Development Assessment Commission, 2000, HCA 5. I refer to paragraphs 43, 54.
Yes, Mr. Kuksal, what do you want me to do? You're just referring to all these things.
To consider them. To consider them.
Shall we adjourn today?
It's scandalous, Your Honor. You're not concerned about the allegations that have been made about you.
When do you want me?
All you're concerned about is basically implementing an agenda that you have.
Mr. Kuksal, I'll tell you what you're mentioning all of these cases, you're expecting me to go and look at them, and
I'm expecting you to charge me with contempt. The things that I've said, if they're repeated in public, if the public knows that this was said, which it will.
But why didn't you, I say again, if you?
No, Your Honor, charge me with contempt.
If you'd given some notice.
If I'm making these allegations improperly, you charge me with contempt.
All right, all I was raising was
and I'm saying it's scandalous, it's dishonorable.
Sense of dissatisfaction that you just throw up all these cases in oral argument.
Your Honor, if you do not charge me with contempt, it will bring the administration of justice into disrepute after I've said the things that I've said. I think it would be a precedent of its own sort which would be deserving of exceptional publicity.
So what do you want me to do? Go and read all these cases?
I'm saying charge me with contempt if I'm making these allegations improperly.
But I'm talking about all these authorities you're referring to.
That's not the point, Your Honor. You're missing the point. You are bringing the administration of justice into disrepute. This court does not have the resources to check that everybody will comply with what is required.
Yes.
There is a good, fair basis upon which people submit to the jurisdiction. What you're doing is undermining that. And this is a scourge on your peers. In Arthur Yates & Co. Pty Limited vs. Vegetable Seeds Committee 194551 Argus LR 474.
Okay. How many cases are you going to refer to?
I have less than 20.
Well, Mr. Kuksal, why haven't you put it in writing?
So I said to Your Honor via email, or someone said on my behalf, that we could put the submissions in by this morning. Your Honor basically prevented us from doing that.
All right.
And again, I offered to provide Your Honor with a copy earlier today before starting.
I'm trying to work out how I go about dealing with this recusal application when you've been talking for the best part of an hour now and you're just still referring to case after case after case.
I don't know how much of what Your Honor thought, but I made some very serious allegations and
I know you have.
In those, Your Honor, either I'm right, and by right I mean either I am doing this dishonestly and it is ostensible that I'm doing it dishonestly, in that circumstance I've committed a contempt of court and I should be charged and tried. If I'm not making those allegations in an ostensibly dishonest way, then Your Honor must recuse himself. That's the law.
So if somebody in your position as a litigant makes a series of dishonest allegations in a proceeding, the proceeding has to stop until it has been investigated about whether those allegations are true or not, or whether the person making the allegations should be charged with contempt of court.
Yes, it's scandalous that you're even asking me that. That's basically the law, because where those allegations are made, the public needs to know whether the allegations were being made to obstruct the administration of justice or whether there was any truth to them, because the law is that not only should justice be done, but it should appear to be done. Now, there is no justice if there is a possibility that what I'm saying is right. If what I'm saying is wrong, that's why the contempt, Your Honor. It's shocking that, Your Honor, that I have to address Your Honor about this. The whole reason why it is a criminal offense to make those allegations without any basis is precisely because the impact that those allegations have on the conduct of a proceeding. It is not an offense to allege things against any other member of the public. One may be sued for defamation. That's a whole different thing. But it's not an offense. Judges are not higher than members of the public. Notwithstanding that, it is a contempt of law to make those allegations against a judge precisely because when those allegations are raised, they impede the proper administration of justice, and therefore it is a serious matter that must be treated as seriously. And that is the deterrent. People do not make those allegations, and because I've made that allegation and the court charges me or considers the veracity of those allegations, it will not lead to a preponderance of those allegations being made as a means to obstruct the natural flow of proceedings, because the criminal offense that I would have committed and the punishment to which I would have been subjected would be the deterrent. But conversely, if Your Honor allows me to do this without determining, it will set a precedent for people to make these allegations. And other judges will not obviously ignore the law that, like Your Honor is doing, so it will actually obstruct the proceedings. And Your Honor is setting a very nasty precedent. I do not know how Your Honor can face another litigant where the litigant refers to what I said about Your Honor and repeat those things. In fact, I mean that the basic issue arises from the fact that Your Honor has seen the evidence of the LSBC's corrupt and criminal conduct. Your Honor has considered that evidence and then decided that he will prevent us from relying on the evidence of that conduct and prevent us from raising issues of their misdemeanor and crimes and the conspiracy in furtherance of which they were exercised and simply presume the validity of their decisions, which is not something that the law allows Your Honor to do. In fact, the law is explicitly clear. The Constitution is clear that a public body can only exercise its functions under the law so long as they comply with the Lang test, that's LANGE test laid out by the High Court in Lang v Australian Broadcasting Corporation, 1997, 189 CLR 520, and the test of proportionality, which has been laid out in a number of authorities, including Miller v TCN Channel Pty Limited, 1989, HCA 60, Sic. Firstly, they must be acting in accordance with the law, strictly in accordance in the law, and only intervening in people's personal business to the extent that there is an overriding public interest to intervene and the law authorizes them to do that. Secondly, the intervention can be in no greater than the overriding public interest obliges. What the LSBC has done has been completely without any proper basis. In fact, it has done those things to essentially contravene the objectives of the uniform law. And Your Honor has essentially stated that he will accept the validity of their decisions and punish Mr. Ansell for complying with the law, for not complying with unlawful orders. That's why I had said on the 10th of July, that excerpt that I read from Martin Luther King's letter, words, I said essentially the same thing, in other words, on the 10th of July when I said in this proceeding when I told Your Honor that Your Honor's decision was morally perverse. And I refer Your Honor to the transcript of that hearing, pp 38 to 61. And Your Honor had asked me what was so morally perverse about it, and I said that we had started this proceeding. We alleged that they were trying to improperly threaten and intimidate Mr. Ansell with the cancellation of his practicing certificate prior to the starting of the proceeding. And it was after this that the proceeding was started, that they carried through on those allegations. And a number of other things were alleged. Those things were essentially done in contempt of court. Those matters have been raised in the originating motion and subsequent application. Your Honor has then scandalously refused to consider those matters and invited given the LSB indications about how it can try and evade a judicial determination of those matters. That's in addition to the fact that Your Honor has asked me to contravene what Your Honor considered to be an appropriate intervention order, then prevented me from having a judicial review of that matter be undertaken by this court, prevented me from having my injunction application heard in that matter, and all the other things that we've alleged against Your Honor. There is clearly the possibility that some people would agree that what Your Honor has done has not been perfectly compatible with assisting in a fair resolution of this matter. In fact, what Your Honor has done is starkly in contradiction with orders that other judges have made and indications that other judges have made about how this and the related proceeding should proceed. So in those circumstances, all three of us should be charged for raising just the fact that we are making these complaints externally and raising those matters publicly. If it was being done in bad faith, it's a contempt of court. It's sub judice contempt. I have put those matters before the court. The court has to consider whether or not it's appropriate to charge the plaintiffs in this matter, and if the court doesn't, then I cannot see how the court can continue to have any more authority in hearing this matter. The court clearly does not have any confidence as far as the plaintiffs are concerned. It cannot be doubted that Your Honor is my foe or that I have any other feeling. It cannot be doubted that I hold those feelings with the most intense seriousness or earnestness that I can hold any feeling. In my view, Your Honor has obstructed the administration of justice more than the LSBC. And Your Honor cannot be a judge in a matter where a person that is making those allegations against Your Honor, a person that is Your Honor's adversary, is bringing claims. It scandalizes the administration of justice. And I note that the other two plaintiffs may not be as vocal in their criticism, but they have made every complaint that I have made alleging criminal conduct by Your Honor. And Your Honor has acted irregularly, to say the least, in respect of a number of matters, including on Wednesday, when Your Honor kicked me out of the court in relation to the Anstie cross-examination.
Yes.
Then when, Your Honor's disappointment, Ms. Zhu did fine and cross-examined Mr. Davidson well, Your Honor prevented us from having a hearing in open court. And I was not heard about this matter. Your Honor suspended the proceeding without even indicating to me that there was a possibility that might happen. I was only being kicked out in respect of the Anstie cross-examination, then Your Honor wrapped up the proceeding because it was not going so well.
And didn't we proceed with the other witness?
No, you didn't tell me that that was happening. I had no idea. I was only being kicked out in respect of the Anstey cross-examination.
Yes, and then after the Anstey witness.
You never informed me that the other cross-examination would take place after that. Or you considered matters that were not even put to me or that they weren't even raised before. I had no idea that you would consider those matters. And by the way, all of that happened in the context where you had deferred the hearing of the recusal application, so big surprise about how you were going to rule on the recusal application.
Yes.
You made those orders after promising me that you will not make any substantial orders in respect of the proceeding until the recusal application is decided, and then you turned the hearing of the matter upside down. You are improvising to see what would fit the LSB.
Okay.
Those are the allegations that we're making against Your Honor. And I cannot say anything more than repeating that Your Honor said that the credibility of a witness against whom we had submitted abundant material was not an issue in the matter. That is scandalous. The application that they're bringing today, it's brought when such circumstances exist, when the integrity of the proceeding itself is challenged on the grounds that it's an ostensible abuse of process. Your Honor has still not answered whether or not Your Honor's chambers has had private communication with the LSBC, including in 2021, a matter that we raised previously. We have raised that matter because, as we had previously clarified, the LSBC had written to a number of other judges, in fact, every judge who was involved in the hearing of the matter involving People Shop or me. The federal court judge, Justice Wheelahan, had then forwarded the correspondence that His Honor had received. The LSBC has itself confirmed to us that it has written to the courts. That evidence is before Your Honor. It's exhibited to my affidavit of the 17th of August filed in this proceeding. Eva Malupo had confirmed to the court. Now, in those circumstances where we say that Your Honor has had a tendency of considering evidence that was not before him, including the affidavits of Ms. Delara Anaz and her parents that were filed after the filing of the submitting notice, and that His Honor had purportedly said that he has not considered whilst holding them in his judgment and then later accepting that he had considered it.
Yes.
So that then the private correspondence that Your Honor has had with Mr. Anaz, the evidence that Your Honor has received through those private correspondences and made rulings reliant on those documents, and then everything that is happening in this matter, and the fact that in the first proceeding that I appeared before Your Honor basically said that Your Honor prevented me from raising some allegations on the originating motion because I was raising them against a lawyer, and Your Honor had said, and has not denied this is part of the transcript, that Your Honor would be comfortable if those allegations were made.
12.30, Mr. Kuksal. How long have you got?
I'm finishing up.
Good.
But I would rely on the authorities, and I'm just going to read them, the paragraph numbers and the names, so Your Honor can.
Is there anything that goes against the fundamental proposition that it's what the reasonable lay observer would think, whether the reasonable lay observer might think?
Yes, so Your Honor, the reasonable lay observer test applies when the court has to decide a matter that can be decided where what we say an evaluative judgment is involved. What we're saying is that Your Honor's disqualified, which is a whole different test because Your Honor is our adversary. You cannot be a judge in your own cause. We say the way you settled these proceedings will impact our claims against you. And you are doing this improperly to cause detriment to us like you did with the prothonotary. So we say that this is not a lay observer test situation. We say that you're disqualified from hearing this matter, and to the extent that we're cooperating, it is only to prevent further material prejudice. But none of us consider Your Honor to be a legitimate judge in this matter.
Yes.
And we have made a criminal complaint that Your Honor is perverting the course of justice in this matter. In those circumstances, it is scandalous for Your Honor to continue hearing this matter. One way or the other, Your Honor should lead the charges with contempt, and we can face an impartial judge about why we made those allegations. Or Your Honor should recuse himself, because Your Honor is only making this matter bigger every day by continuing to act in circumstances where Your Honor's involvement outrages the plaintiffs and defendants. For proper reasons, Your Honor has also refused to go into the merits of why those allegations have been made against him. If we are making them either because we're insane or because we are dishonest, the public must know that.
What about the possibility that you honestly believe them?
Then you have to go.
But they're wrong. You honestly but mistakenly hold those views. Why should I recuse myself if that's the situation?
Because you will not command confidence in this proceeding. It's not in the public interest that a judge who is constantly the subject of what would otherwise be abuse, if it was not justified, continue to sit in the matter. It has a mental health toll on me that I go into a proceeding and make those. I have to be prepared for several hours before this and several hours after this. I'm in a different state because I'm going into court and making very serious allegations and calling a judge, effectively, a scoundrel. It's not a good thing. It's not good. I know the other two defendants are traumatized on occasion because of the things that we have to allege against Your Honor. It is not good for the administration of justice that Your Honor continue to hear this matter. And I also note that it's the first time that I've made accusations that serious against a Supreme Court judge. I've made them against a magistrate who essentially relied on Your Honor's judgments to say that he shouldn't recuse himself. It's Magistrate Williams who was presiding over the Oni matter, and he prevented the cross-examination of police witnesses against whom we had recordings which were admitted by the other side as accurate, and those officers are now being investigated by IBAC to bring charges. The charges being contemplated against them by IBAC are for perversion of the course of justice and misconduct in public office. So I do not have a habit of raising these allegations against a judge for no reason. I've appeared in several hundred proceedings over the last 2 years. And I've raised recusal applications on multiple occasions, but they've always been compliant to the case. What we're saying is that you're going against the law. You've not addressed us about why you're not going against the law, except for saying that go and appeal me, but you're not clarifying how you're going around the High Court decisions that we are citing or the statutory provisions that we're citing. So in those circumstances, where the Legal Services Board, Your Honor, has seen video recordings of Channel 9 reporters recording the content of the case files. In the High Court judgment against, or in the matter involving Ems Gorbold, the High Court had said that Victoria Police had essentially lost public confidence for a very long time, and it would take them a very long time to win back public trust, and it was the most scandalous thing that have ever taken place. In this case it was worse, because the Legal Services Board seized my case files, then wrote to the police and said they can give them all of the files. Your Honor has that on evidence. And they're not denying it. It's an email exhibited to an affidavit. The email is from the police officer that had accompanied Mr. Bowes to seize the assets of the firm, and that person, the police officer, senior constable, I think it's Michael Howard, he says to Mr. Oni that Mr. Bowes had seized all the case files and any other document that I or Ems Zoo or Ems Di Gregorio may have had in the office, and Mr. Oni is welcome to all of those documents. Now, this is much worse than what had happened in the Gorbold case as far as the regulation of the legal profession is concerned. Your Honor has essentially prevented us from raising those matters. The application today has been effectively incited by Your Honor. The LSBC had made an application to have this very application amended because they were no longer confident that this could continue on its own. Then Your Honor, as the transcript shows, essentially pressured them into bringing this application today without evidence. In circumstances where the application couldn't possibly succeed because there's so much credible evidence against him, the way the originating motion is formulated is, firstly, correct, but even it weren't, the authorities are clear that it does not matter. The originating motion is supposed to be just a guide. If the evidence is before the court, then the court cannot dismiss the matter. There's High Court authorities that I can cite about that, including the Waterboard vs. Moustakis, MOUSTAKAS, 1998, HCA 12.
Now you're talking about the merits of the case, aren't you?
No, I'm saying
the merits are the strikeout rather than the recusal.
No, I'm saying that another basis of recusal is that Your Honor invited this application after being familiar with the evidence that he have against the LSBC. Your Honor knows that we have credible allegations against the LSBC because you know the evidence, and you keep talking about efficiency and all the matters which are really irrelevant when it comes to a proceeding of this sort. You have sought to punish us for non-compliance with procedural orders that you have tactically made in circumstances that you are aware that we cannot comply with them. You're, in our submission, clearly not interested in deciding the truth of the matter. You made it blatantly clear as much. What you're turning this proceeding into is an exercise in technicality, specious technicality to evade the true consequences for people's actions. That's incompatible with being a judge, especially in a matter of this sort. So either Your Honor has improperly benefited the LSBC through procedural tactics or Your Honor hasn't. But we have all the evidence against him, and there is no way that it doesn't come to the attention of every resident in this state so long as I can help it. So what this court is doing is forcing us to try this matter in public by refusing to consider this matter where it should be considered. And again, I'm honor-bound to have this matter tried and the evidence properly considered by reasonable people. If it has to be in the public, it has to be in the public. But it is scandalous for the administration of justice that it has to proceed that way because Your Honor would not hear our applications. And the other problem for us is that if you allow this to transpire, it essentially puts an end to all the claims that we have against the LSB, Victoria Police, and it sets a very nasty precedent, not just for us but for the public at large. So we have a moral duty to not permit Your Honor to obstruct the administration of justice. In those circumstances, we say that it is contrary to the maintenance of public confidence in the administration of justice that Your Honor continue with the hearing of the matter. Even if you are deluded, firstly, you'd have to be criminally insane to, not criminally, sorry, but you have to be insane to the extent of being incompetent. If Your Honor does not believe that we can understand the legal basis of the allegations that we're making, then that is in itself a prejudice that Your Honor has. It reveals that Your Honor will not take us seriously when we make those allegations against the LSB. If these allegations, when we make them against Your Honor considers them to be not even worthy of a serious consideration, then that in itself reveals a prejudice that Your Honor has in relation to the credibility of the allegations that we make against the LSB, because they're a government body, we're making similar allegations, and it leads to a reasonable apprehension that Your Honor may simply think that just like we're making allegations against Your Honor, the allegations that we're making against him are probably ill-conceived and do not warrant consideration. In any event, Your Honor must consider the substance of the allegations that we're making, allow us to identify the evidence that we rely on against Your Honor, allow us to subpoena documents, decide the substance of the allegations against himself and against the LSBC if Your Honor continues in this matter, but it is that the safer course of action is for Your Honor to recuse himself or charge us with contempt. But Your Honor's continued involvement in this matter, where we continue to allege that Your Honor is simply doing this to obstruct the true determination of our claims, is not going to be helpful, even for the purposes for which Your Honor is purportedly doing it, which is the efficient. What Your Honor has done since the involvement in this proceeding has only increased the allegations that we've made against the LSBC and against other people. So now there are more claims.
Right.
So now, Your Honor, if I could just quickly read the authorities, the names only and the paragraph numbers. Or I can provide a copy.
No. Give me the proposition.
The proposition is this: if a decision made by an administrative body is made for an improper person, it is no decision at law, which is exactly contrary to what Your Honor has said and the authorities that say this.
So just tie that into the bias application. You say the decision's so bad that it must be biased.
No. I'm saying that you know what the law is because I've told you what the law is. You're refusing to acknowledge what the true law is.
So I'm making deliberate errors of law.
Not errors of law. You are acting in contempt of the law to allow to basically take care of the matter for the LSBC. To improperly dismiss our claims against the LSBC, you're acting in contempt of the law. That's what the submission is. You have refused to accept what the law is, and you have refused to provide a justification for it. Now, the authorities that I'm citing basically said that if an administrative body makes a decision for an improper purpose, it is no decision at law. And that applies to the courts as well, the inferior courts, and applies in the case of a superior court where the judge is not acting like a judge. So I rely on Arthur Yates and Co. Pty Limited versus Vegetable Seeds Committee. The citation is 194572 CLR 37.
Yes.
It is not the English view of law that whatever is officially done is the law.
All right, I've made a note that you say that one.
Let me cite the authorities. You have to address them later.
One of the reasons for bias is that I've made decisions that are
in contempt of the law.
Blatantly contrary to legal principle.
I'm saying in contempt of the law. But that is the submission, that you have shown a contemptuous attitude toward the law by refusing to acknowledge the law or give reasons addressing the specific authorities that we cite.
Yes.
I've said I've relied on Enfield, City Corporation of Enfield v. Planning Commission.
Yes.
The citation for that is 2001-69 ALR 400. Then I've also relied on RV TUI.
So you want me to go and look at each of these passages?
Well, you should have, because you've ruled on these matters previously.
But practically, in terms of today.
Do you not remember that those authorities stand for?
In terms of today, do you want me to?
Yes, I want you to address each allegation that's.
So we'll adjourn after today and come back tomorrow, will we, if?
I'm not even thinking about that.
I'll give you my.
I'm thinking about the injustice that you're perpetrating and about I don't even think that there's a theoretical possibility, but in case that I'm deluded or for some other reason I'm mistaken, then you have a duty to correct me too, because I will not be able to properly prosecute my matter. Gorton J. I don't know. But just in terms of.
I don't know, but just in terms of.
You don't know whether you have a duty to correct me if I'm mistakenly of the sincere view that you're acting in contempt of the law.
I have a duty to decide the case, Mr. Kuksal.
That's not what I'm saying. I'm saying that because of your conduct that has led me to form the view that I have. You have a duty to correct my misunderstanding if you are of the view that I'm sincerely making those allegations. And I'm not insane, but those allegations are ill-founded because you know that I will not be able to properly prosecute my matter before you unless that is done. And because of that, yes, you have a fiduciary duty or a duty that has a fiduciary nature because that duty cannot be conflicted with any other duty. It's a complicated submission. You try to reduce it. What you did over the last few days has necessitated this.
Mr. Kuksal, yes.
What I mean, you communicated with the prothonotary, which influenced the prothonotary.
You keep saying that. I don't accept it, but you just assert that.
Well, reduce the correspondence, then.
I'm not going to do anything, Mr. Kuksal, in terms of your demands. I'm going to respond to your application.
Okay, well, Your Honor, I'm not finished. I wish to cite the.
How much longer have you got?
Well, it depends on how much interruption I will be subjected to.
Okay, well, suppose I don't interrupt you. How much longer have you got? I'll give you 9 minutes.
9 minutes is not enough.
No, well, that's all you.
That's completely arbitrary, and it's not.
Well, Mr. Kuksal, I'll tell you what I might do then is I'll order you to put in a written submission by 3.30 tonight of no more than 20 pages.
3.30 tonight?
3.30 this afternoon. You can go and do it now.
Your Honor, what you're doing again is creating circumstances where you're putting very sharp deadlines in, you're setting us up for failure, and then you will rely on that.
Yes.
Give us a proper opportunity. Give until tomorrow morning or something more reasonable. It doesn't, Your Honor, this is scandalous. What you're doing this is how the prothonotary will also get to know about this because you're raising aspersions about the propriety of the application in open court.
What do you mean?
Which are then communicated to the prothonotary by the Legal Services Board and others. And that's how Your Honor is relaying these messages to the prothonotary about what they can and cannot do. We note that it was completely improper for the prothonotary to reject an application in which they were themselves a party on the basis that not because it was in violation of any rule but because it seemed very complicated and maybe we don't have a case. And the other allegation about the obstruction of this proceeding and other matters, the prothonotary is ostensibly influenced by what Your Honor has said. Now, whether it was directly communicated or communicated through the LSBC is a different matter, but Your Honor is implicated in the.
All right.
And that's precisely because of all.
Well, if I let you just finish your submission orally, how long are you going to be? You said an hour.
Well, you said you won't interrupt me.
It's now 5.
I have no confidence that you will not interrupt me.
Okay, let's assume I don't interrupt you.
Well, then let's say half an hour, but.
No, what about if I gave you till? No, but you said this morning. No, just stop for a minute. You said this morning.
No, this.
Just listen. Do you accept that you said this morning you would take an hour if I didn't interrupt?
Firstly, I gave you an estimate.
Yes.
And secondly.
And you were given leave to present the argument because of your estimate.
That's absurd if that was the case.
In my mind, that's right.
If you're saying that you're only letting me speak because you think that I will not speak for long, then you shouldn't be a judge in this matter.
No, if you had told me you would take the whole day, effectively, to run the argument, I would have said you've got to put it in writing.
No, what you do when you interrupt me is that you take me off course and then I have to address that conduct. So I have been completely disrupted.
Mr. Kuksal, I'm going to say nothing for 10 minutes, and then I'm going to leave the bench.
That's not enough because I haven't even advanced 15 minutes of the application that I was making because Your Honor has consistently interrupted me. I mean, there was no 10-minute period for which you did not interrupt me in this matter. And then, given that I think that Your Honor is doing it, dishonestly, I have to make submissions to address that. This has just been a constant back and forth because Your Honor cannot hear those things in silence, which I wouldn't blame Your Honor about. Those are very serious things, and nobody should have to hear them if they have not done something horrible.
Mr. McAuliffe, can I ask you something? One way or another, this recusal application is being made, and it's being prosecuted.
Yes.
And it's going to have to be dealt with. Are you in a position to come back tomorrow?
I am, yes.
All right, Mr. Kuksal, I'll let you finish it's 1 o'clock now. If the parties are happy, I'll let you continue until 1.30, and then I'll adjourn until tomorrow morning and consider what you've got to say.
So I will raise the authority names and paragraphs and I would like Your Honor to address those authorities.
Well, I'll address them if I feel the need to address them, but you refer them, and if I don't address them, you can complain about it. But you tell me.
I'll raise a recusal application about it because what you're doing is in contempt of the law.
Yes, all right, Mr. Kuksal. So I'm telling you at 12.30, I'm going to adjourn, so you've got just over half an hour. 1.30, I meant.
So, Your Honor, this is from Enfields v. Development.
Yes. Can you read the citations out quite slowly?
Yes, and again, I can repeat them if Your Honor requires. So this is Enfield v. Development Assessment Commission 2169, A for Apple, L for London, R for Review, ALR 400. And I am relying on paragraphs 18, 22, 53, and 38, paragraph 50.
It helps me, Mr. Kuksal, if you express in a sentence, say, what the proposition of law that you say the case supports.
Okay, I'll read this paragraph for emphasis. A fundamental consideration in this field of discourse, this is public law and judicial review determinations, was emphasized by Justice Brennan in Attorney General, New South Wales v. Quinn. The citation is 1990, 170.
No, Mr. Kuksal.
No, this is what they've said.
Now you're reading another. I'm telling you, tell me the proposition of law you say, and I want you to give me the proposition of law and then the case and the citation that supports it.
Okay, I cannot express it better than they have.
All right.
And it's very succinctly done. An essential characteristic of the judicature is that it declares and enforces the law which determines the limits of the power conferred by statute upon administrative decision makers. That's an essential characteristic of the judication. And then they cite this passage, there is in our society, as Professor Yaffa says, a profound tradition taught reliance on the courts as the ultimate guardian and assurance of the limits set upon administrative power by the Constitution, by the constitutions and legislatures. Judicial review of administrative action stands on a different footing from constitutional adjudication, both historically and functionally. In part, no doubt, because alternative methods of control, both political and administrative in nature, are available to confine agencies within bounds. There has never been a pervasive notion that limited government mandated an all-encompassing duty to supply all of the relevant meaning of statutes. Essentially, what the court is saying is that once the court is familiar with an abuse of power by the administrative body of the government, then the court will find a way of providing remedy. It is the court's duty to do that. Throughout this authority, in fact, there is a section of the authority which says judicial deference to the administrative, and there they clarify that it is completely inappropriate. I rely on the whole of this authority, Enfield v. Planning Commission. It's not a long authority, and what has been emphasized in this authority is that the main function of the court is to prevent an abuse of authority by the executive. And irrespective of how the court becomes aware of it in a proceeding, the court will provide remedies. And where administrative remedies like judicial review are not appropriate, that's where the flexibility of declaratory relief comes in. And the court will never look the other way when there's an abuse of authority by the administrative. Once it is appreciated that the rule of law requires the courts to grant whatever remedies are available and appropriate to ensure that those possessed of executive and administrative powers exercise them only in accordance with the laws which govern their exercise, it follows that there is very limited scope for the notion of judicial deference with respect to findings by an administrative body or jurisdictional facts. Where, as here, the legality of an executive or administrative decision or of action taken pursuant to a decision of that kind depends on the existence of a particular fact or factual situation, it is the function of a court, when its jurisdiction is invoked, to determine, for itself, whether the fact or the factual situation does or does not exist. On Wednesday, we wanted to cross-examine Mr. Anstey about whether or not the circumstances in which he had appointed the manager had existed. Your Honor prevented me from doing that. All the decisions that they have taken rely on jurisdictional facts. It was your duty to ascertain the truth of those facts. All the authorities in relation to uniform law or the determination of allegations against lawyers also repeat that. You have essentially ignored them and refused to comment about them. We've put a number of them to you, including Dennis v. Council of the Law Society of New South Wales 2014, NSWSC 1487 and Cahill v. Victorian Legal Services Commissioner 2017, VSC 177. All you basically say is that, I've read those authorities. They're not on the point. You don't address the contentions raised in those authorities and how they're irrelevant or why you think it doesn't apply. And I can point out some decisions where courts have addressed authorities and the proper manner in which it should be done, but I don't do that for the sake of avoiding the impression that I'm being condescending. In DPP v. Edwards 2012 VSCA 293, I rely on paragraphs 40, 186, 192. Basically what the court said is that considering that the decisions of administrative bodies do now proceed with a presumption of regularity may be inefficient to the resolution of a number of matters, but the court has no choice because that is what the law is and that is what High Court has repeatedly emphasized the law is. So no decision made by an inferior court or an executive body can be presumed to be correct, and it can always be challenged. Paragraphs 40, 186, 192.
What was the case again? I didn't.
This has been raised previously with Your Honor. DPP v. Edwards, 2012.
DPP v. Edwards.
Yes, Edwards, EDWARDS, 2012, VSCA 293. Justice Ginane has accepted.
VSCA
293.
293.
2012, VSCA 293.
At paragraph
40, 186, 192. The court emphasizes, without any ambiguity, that no decision of an inferior court or the executive could be presumed to be regular, and that's where the principle of legality comes in. Because we have a common law right to challenge that decision unless the legislature specifically says otherwise, which it doesn't in the case of uniform law, we have the right to challenge and have a court determine that the veracity of that decision. And for this proposition, I also raise Stanley v. DPP New South Wales, 2023, HCA 3.
Stanley
versus DPP of New South Wales, 2023, HCA 3.
2023.
Yes, HCA, High Court of Australia.
HCA, yes.
3. Paragraphs 14 to 19.
Yes.
And then 55, 82, 82, and 96 to 100.
Yes.
I also raise Owsley v. the Queen.
Which one?
1997.
Mr. Kuksal, you've just read a name. I didn't get it.
Owsley, OUS.
Yes.
LEY. I'm sorry. Versus the Queen.
Yes.
1997148 CLR 150. Sorry, CLR 510. And this is not a long authority.
What's it mean?
So essentially what happened in the authority is that a Supreme Court judge has issued an interception order pursuant to which criminal proceedings were started against a person. That person sought to challenge the validity of the order itself. If that interception warrant had been set aside, then his view was the proceeding should be dismissed. He did that in the county court. The county court judge said that he couldn't possibly review the decision of a Supreme Court judge. The High Court found that the county court judge had been mistaken because the warrant was an administrative order, and all administrative orders can be judicially reviewed and should be judicially reviewed when they're the subject of a collateral attack. So they found that the county court judge had committed an error of law in refusing to review the order of a Supreme Court judge because it was an administrative order, but ultimately, after considering the evidence, found that the person had a proper case against him and then decided to make an order finding that the person was guilty. They emphasized though that the county court judge had no option but to rule on, after considering the evidence and the submissions, the collateral attack that the person had raised against the administrative order. So this authority clarifies that the judge doesn't have an option, as do the other authorities, that once a collateral attack is raised against an administrative decision, the court has to decide it for himself or for itself whether or not that order is proper. We say that Your Honor, well, everything that Your Honor has done in these proceedings has been in stark contrast to those principles, in circumstances where we've repeatedly advised the court of those principles, so there could have been no mistake, and Your Honor has also not addressed us about how Your Honor is reasoning that Your Honor can evade them. So we say Your Honor is acting in contempt of the law, and we say that Your Honor has prevented us from having the Attorney General intervene to prevent us from this exploitation. Now, I rely on Houcher v. Minister of Immigration and Ethnic Affairs, 1990, that's Houcher v. Minister of Immigrations and Ethnic Affairs, 1990, HCA 22. In that authority, so firstly, Your Honor, because criminal proceedings involve the right to due process, all court proceedings, not criminal proceedings. All court proceedings necessarily involve the determination of human rights. We say it was scandalous for Your Honor to say that there was no consideration of human rights involved in the matter and then prevent us from relying on the protection of the Attorney General and the assistance of the Human Rights Commission from preventing Your Honor to effect an injustice in this matter, further to Your Honor's conspiracy with the LSBC. But Houcher in particular considers the case of renewal of licenses and says that they raise human rights issues. I refer the court to paragraphs 12, 14, 16, 17, and 23 of Houcher v. Minister for Immigration and Ethnic Affairs. Then I refer the court to Batrani v. Forster.
Do I really need to look at all these cases?
Yes, Batrani v. Forster. This is Batrouney v. Forster, FORSTER. The citation is 2015 VSC 230. There's another case involving the same parties, which I'm going to refer to for complete context, Batrani v. Forster, No. 2, 2015, VSC 541. In this proceeding, essentially, the practicing certificate of a lawyer had been suspended. That lawyer acting in proceedings against the board, and this was before the court had clarified that its position in Bell Lawyers, the High Court authority, where the court clarified that lawyers working in their own case cannot be reimbursed for the expenses associated with their own costs for the time that they've spent on the case. So this case precedes that one, and in this matter, the lawyer ultimately sought costs for their own involvement after the suspension of their practicing certificate. And the court determined that because the court had ruled against the board, the person should be entitled to those costs. So that there is no presumption of regularity in relation to the non-renewal of license. The same is emphasized by Carson v. Legal Services Commissioner, 2000, NSWCA 308, Griffin.
New South Wales.
CA.
2000, NSWCA.
308.
308, yes.
Griffin v. Law Council of New South Wales, the Law Society of New South Wales, 2016, NSWCA 364, Murray v. Legal Services Commissioner.
No, you've got to tell me what the principle is.
That's the principle. There's no presumption of regularity. If the suspension of license has not proceeded based on proper legal process or has proceeded on and before an improper purpose, then it is no decision at law, and the court must decide that, obviously.
Yes, so you say, I got it wrong. Yes.
Not wrong.
All right.
You knew that this was the case.
All right.
And then you only did this after we started subpoenaing documents.
All right, Mr. Kuksal.
You were agreeing with us about that until we subpoenaed.
I'm sorry I asked you question. It's 16 minutes past.
Yes, but to clarify, you only started taking this approach after we subpoenaed the documents to prevent us from subpoenaing documents. Until then, we have relied on the transcript of a hearing in the relating proceeding 3994 from the 19th of February. And then there's one from the 28th of February, I understand. At that time in the proceeding, you had accepted that the determination of the legitimacy of the proceedings was something that the court had to ultimately come to a resolution of, and that was the position of Justice Forbes. Your Honour had agreed with that. On the last occasion when I was in court with Mr. Ansell, Your Honour said to Mr. Ansell, well, that was a very long time ago, and what's the point of all of that now? We say that brings the administration of justice into disrepute. Then we also rely on AJH Lawyers v. Matheson Nominees Pty Limited 2015, VSCA 227, Menon v. Council of Law Society of New South Wales 2016, NSWSC 1322, and I've previously a High Court, before that, actually, on WA Pines, PINES, Pty Limited vs. Bannerman. This is about the appointment of people to audit the operation of a company. It's pursuant to the Consumer Act, but the legislation is the same. Both legislations rely on, so both the ACCC or the Corporation and Consumer, the legislation that ACCC relies on for the regulation of the consumer affairs is the ASIC Act. Uniform law also relies on the ASIC Act in relation to examination of people. They both involve the same statutes. So WA Pines Pty Limited vs. Bannerman, BANNERMAN. The citation for this is 198041 FLR, so Federal Court Law Report 175. This sets out the matters that the court must consider in relation to the notices of appointment of various officers. Now, I've previously raised with the court the MN Legal and Management Consultant v. New South Wales Council of Law Society 2018, NSWSC 1410. Dennis v. Council of the Law Society of New South Wales 2014. This one in particular is very relevant because, again, legal services regulation, and there was an examiner appointed. The lawyer did not cooperate with the appointment and challenged the validity in the court. The court found in favor of the lawyer and confirmed that there was no presumption of regularity. So, 2014, NSWSC 1487. Berger, BERGER, v. Council of Law Society New South Wales 2013, NSWSC 1080.
Can you repeat that one?
Yes, BER, so Berger, but instead of U, so Berger v. Council of Law Society New South Wales 2013, NSWSC 1080. And we rely on APLA Limited v. Legal Services Commissioner, New South Wales 2005, HCA 44. This sets out the fact that the right to a lawyer of one's choosing is a constitutional right. The right to act as the court is a constitutional right. Lang v. Australian Broadcasting Corporation, to which I previously referred, 1997, HCA 25. This sets out the manner in which administrative bodies can regulate or perform their duties. Attorney General, South Australia, v. Corporation of the City of Adelaide 2013, HCA 3. This is, again, about the manner in which regulations can be overseen by administrative bodies. And then I also rely on the observations of the Supreme Court of U.S. Supreme Court in relation to the presidential immunity decision that the court had made. I have the citation for the order. It's Trump v. United States 603 U.S. 23 to 939, 2024. I rely on the principal judgment and dissent by Sotomayor. Essentially, Her Honor emphasized that the threat to the rule of law and administration of justice comes more from the improper conduct of the executive, and the court's duty is first to check that. Then any intrusion in the performance of duty by the executive. And that was obviously a very different case, because what the court was considering is whether political rivals can effectively go after each other for performing their duty or decisions taken in the performance of their duty, but the majority did not disagree with Sotomayor about her hallucination of the legal principles, they just disagreed about whether or not they applied. So the fact is that the regulation or the determination of the propriety of the conduct of the executive is one of the foremost responsibilities of the judiciary. So much is also emphasized in Kirk v. Industrial Commission. This is at p. 54, 2010, paragraph 54, 2010, 239 CLR 531. A defining character of state supreme courts is the power to confine inferior courts and tribunals within the limits of their authority to decide by granting relief in the nature of prohibition and mandamus, which is what we are seeking. And as explained further in these reasons, also certiorari, which is also what we're seeking. Directed to inferior courts and tribunals on grounds of jurisdictional error. They're raising those issues. Certiorari, prohibition and mandamus are now raised exclusively through Order 56, which is the judicial review provision.
126, Mr. Kuksal.
Yes, Your Honor. I'm concerned you're not paying attention to the.
Well, I'm trying to listen.
Well, it doesn't appear so.
Mr. Kuksal 126.
So we rely on that. We also rely on RV Australian Stevedoring Industry Board, ex parte Melbourne Stevedoring Company, 1953, 88 CLR 100. It says, while prohibition is not a writ of cause, it is a writ which goes as of right when the prosecutor is directly affected by the course pursued by the tribunal to which the replies, and the prosecutor shows satisfactorily that the tribunal is about to act to his detriment in excess of its authority. So these authorities I've already cited. The authority of RV2E, where essentially what the court, so the citation for RV2E is 1981, 151 CLR 170. What the court emphasized is that, and they literally use the word abdication of judicial responsibility. When the court refuses to consider allegations of corrupt conduct or malefices by administrative bodies. The court emphasized that it is, the court brings the administration.
What page is this? What was it again?
RV2E.
Yes.
Ex parte Northern Land Council.
Yes.
1981, 151 CLR 170. We have raised this before.
Yes.
The court said that it's an abdication of judicial responsibility if a court refuses to entertain allegations around corrupt conduct and malefice improper purpose. What the court also emphasized is that it is fallacious to think that when the court emphasized that those allegations can be raised at any point in any proceeding, not just formally as judicial review proceedings. Every party has a right. And the court emphasized that it is nonsensical to assert that will frustrate the administration of justice by delaying processes or the operation of the administrative bodies, because what they, very appropriately emphasized is that when that doesn't happen, it only leads to further delays and further applications, and more importantly, the administrator is not about the law. So the protection of human rights necessitates that those applications be heard and decided by court, and if they are decided promptly when they are raised, then it is overall efficient for the administration of justice because it prevents the matter from getting bigger later on, and it incentivizes the administrative to follow the law. If that's not done, then they will continue to break the law and more allegations of that sort will inevitably be raised. There's Ainsworth v. Criminal Justice Commission 1992-175 CLR 564. In that case, the court emphasized that the declaratory relief option is the ultimate flexibility that the court has to do justice in circumstances where all the other matters may be inaccessible on account of technicality. Your Honor has taken the exact opposite approach.
Yes.
I note for the record that Your Honor has previously been taken to these authorities, especially through the application of the 26th of June. Your Honor referred to those authorities including Kirk and said they raise unremarkable issues about the law and it's not relevant. Now, we've specifically said that Your Honor is acting in contempt of the law because Your Honor has been told specifically that there's no presumption of regularity. Your Honor has acted as if there is a presumption of regularity without clarifying what the basis of that assertion is, and then prevented us from testing the veracity of the evidence, the credibility of the witnesses in a matter. If Your Honor did not ignore the law or did not act in contempt of that law, there would have been no basis to prevent us from questioning the credibility of our accuser. By the way, it's such a fundamental proposition that it couldn't have been done anyway, and that's where the principle of legality comes in. The law is a living, breathing institution, and if it is arbitrarily suppressed in one part, it becomes incoherent. Those were the submissions that I wanted to make.
Thanks, Mr. Kuksal.
I note that I finished at 2.30 to 1.30, sorry.
You did, just give me a sec. All right, I think in the circumstances, it's probably best if we adjourn now till tomorrow morning. We may need to finish it tomorrow though, if I don't recuse myself. If I recuse myself, we'll definitely finish by tomorrow morning. Otherwise, I'll just have to go on to hear the argument tomorrow.
Your Honor, we would require reasons for that.
All right.
We're making some very serious allegations. It would be improper for Your Honor to.
Thanks, Mr. Kuksal.
And we also intend to file notices for the Attorney General's intervention in these proceedings.
Right.
Which we will do today. And the Human Rights Commissions.
Right.
Both on constitutional grounds and on the grounds that Your Honor we will raise the matters that have transpired last week.
If I don't recuse myself, then my current intention is to hear the strikeout summons tomorrow. And if Ms.
I'm foreshadowing beforehand that we will file those notices today.
Well, I can't stop you filing them, Mr. Kuksal, but I'm telling you my intention.
Yeah, and I'm telling you that we will raise those issues.
Okay.
And we will raise issues of detrimental action because it's a scandalous application that Your Honor has cited.
Mr. Kuksal, so you're saying if I don't recuse myself, you'll be applying for an adjournment tomorrow?
I'm saying that.
What will you be applying for tomorrow morning?
Well, I'm saying that as of this moment, I think you're corrupt and you're conspiring with them to pervert the course of justice.
All right. Okay.
And it's my duty to stop you.
Okay.
Now.
No.
When you say something like you did, that I will conclude the matter tomorrow.
So what I'm saying?
So I think you're acting corruptly. Unless you give me reasons that clarify how I'm wrong.
Mr. Kuksal, if I don't recuse myself and we're back here tomorrow morning, what are you going to do? Are you going to?
It depends on the reasons you give. If you convince me that you're right, then how I'm going to act is different from if you simply scandalously refuse to give reasons.
Mr. Kuksal, suppose I don't convince you that I'm right.
Then I have a duty too.
And what would you do? Would you bring an application?
Yes, I will bring in.
What would the application be?
I have some time to think about more, but as of this moment, we have already decided to file the notices against you.
Okay.
We will publish the content of those notices online.
So what would you be? Are you saying that if I don't recuse myself or?
We would want the Attorney General or another independent body to be involved in this matter.
So you will be applying for an adjournment. If I don't recuse myself, you'll be applying for an adjournment tomorrow.
Well, we will be applying for you to determine about the appropriateness of certain things. But we're crossing a bridge we haven't reached.
Mr. Kuksal.
There's nothing you can say which will help in this situation. It only shows prejudgment.
I'm trying to work out. I don't want a situation where if I don't recuse myself, we end up.
Well, it depends on how you don't recuse yourself. It depends on whether or not you give reasons, whether or not you act in contempt of the law, whether or not you charge us with contempt.
Mr. Kuksal, I don't anticipate that there are any reasons I could give that would satisfy you because you are so strongly of the view that I ought to recuse myself.
Well, then Your Honor fundamentally.
So
has some fundamental misgivings about me. If Your Honor is of the view that also shows prejudgment. What you have decided is that it is pointless to give me reasons, and you're acting in bad faith in that sense.
I haven't decided that, Mr. Kuksal.
You just said what I have.
I'm saying it's.
Your Honor, can we play the recording of this? Because.
No, I'm not, Mr. Kuksal.
You exactly said that. You said you don't think that there's any reason you could give.
I didn't. I said it's unlikely that I could give.
No, that's not what you said. You're twisting your words.
Mr. Kuksal, listen to me. I said I'm not. I said.
I don't think.
It's unlikely I'm going to be able to persuade you.
I don't think you.
I did not say I wasn't going to give reasons. I said I wasn't going to persuade you.
You didn't say unlikely.
Let's work on the assumption that you're not persuaded by something I say.
No, you said what you said indicated that you were of the firm view.
So tomorrow morning, you're going to, if I recuse myself, obviously I recuse myself. If I don't recuse myself, you're going to say that the case can't go ahead.
No, it depends on what reasons you give.
Okay, if I persuade you that I'm right not to recuse myself, then what will you do?
Then I will comply with what your directions are.
Okay, So you'll only bring in the Attorney General issues if you're not satisfied with my reasons for not recusing myself.
As of this moment, we will file it because we have decided.
So I want to get this right.
But if you convince me or convince us that you have acted completely appropriately because of the reasons that you provide, then some of those applications would be misguided and we will withdraw them.
Right,
But as of this moment, you have not clarified to us how you are not acting in contempt of the law because you've been repeatedly told about what the law is. You're then refusing to apply it, and you're doing it in a way that is extremely detrimental to us.
All right, Mr. Kuksal. Well, it sounds a bit like you're saying that if I persuade you in my reasons that I've got a good reason for not recusing myself.
If you convince us that we are mistaken in holding such strong and unequivocal views about your corruption, then we must apologize and comply with your Honor's directions because.
But it sounds a bit like you're saying that if you're not happy with my decision, you.
No, that's not what I'm saying. No, that's not. You're trivializing the matter again.
Then you would be making an application.
You're trivializing the matter.
Then you will bring arguments in favor of an adjournment.
What we're saying is that if you're a corrupt person who's trying to frustrate the administration of justice, then we have a duty to prevent you from doing that because you're a criminal.
Yes, even if that means bringing adjournment applications for other reasons.
Anything besides breaking the law. If you are committing criminal offenses, we have an obligation to prevent you.
If you think I'm doing the wrong thing, you will do anything to prevent it.
That's always the case. Anybody who takes a decision is thinking that they're right.
Right, we'll adjourn till 10:30 tomorrow.